Texas is one of the most landlord-friendly states in the country when it comes to rent increases. And the framework here gives property owners maximum flexibility to set and adjust pricing. If you manage rental property in Texas, you operate in an environment with virtually no government restrictions on how much you can charge. And the state has taken deliberate steps to keep it that way. Texas does not have rent control or rent stabilization of any kind. There is no state statute that limits the amount of a rent increase, the frequency of increases, or that requires landlords to justify their pricing decisions to any regulatory body. Texas has never had rent control, and the state's political and economic philosophy strongly favors free market pricing. But Texas goes even further. The state has one of the strongest rent control preemption statutes in the nation. Under Texas Property Code Section 214.902, a municipality or county cannot adopt an ordinance, resolution, or other measure that would have the effect of controlling the amount of rent charged for private residential or commercial property. This preemption is broadly written and applies to every city, county, and political subdivision in Texas. Houston, Dallas, San Antonio, Austin, Fort Worth, El Paso, none of them can enact rent caps, regardless of local political sentiment. The only narrow exception is that the governor can temporarily suspend the preemption during a declared housing emergency. This provision has never been invoked to implement actual rent control, and the circumstances under which it could be used are extremely limited. This preemption gives Texas landlords complete certainty. You will never need to check whether a Texas city has enacted local rent restrictions because none of them legally can. The rules are the same across the entire state. For month-to-month tenancies, the landlord can raise the rent by providing advance written notice. Texas doesn't have a specific statutory provision establishing a minimum notice period for rent increases on month-to-month tenancies. The general rule is that the landlord must provide notice before the beginning of the next rental period, which for a monthly tenancy means at least one full month's notice. However, the lease can modify this requirement, and many Texas leases specify the notice period for rent changes. So if rent is due on the 1st and you want the increase to take effect on May 1st, you should deliver written notice before April 1st. The notice should clearly state the current rent, the new rent amount, and the effective date. While Texas doesn't require a specific form, putting the notice in writing and delivering it by a documented method is always recommended. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. This is standard. Without a contractual provision permitting adjustments during the term, the landlord must wait until the lease expires to negotiate a new rent. Many Texas leases for multi-year terms include escalation clauses that specify annual increases, which gives both parties certainty about future pricing. When a fixed-term lease expires, the landlord can propose any new rent amount for the renewal or new lease. If the tenant agrees, the new lease is executed at the new rate. If the tenant doesn't agree and the lease expires, the tenant either vacates or, if the landlord accepts rent, the tenancy converts to a month-to-month arrangement, at which point the landlord can implement increases with proper notice. Texas also allows landlords and tenants to negotiate virtually any rent-related terms they want in the lease. The parties can agree to automatic annual increases, increases tied to specific indices, increases triggered by property tax changes, or any other adjustment mechanism. Texas courts enforce these contractual provisions as long as they were agreed to voluntarily by both parties. Now let's cover the restrictions that exist even in this permissive environment. Because having no rent cap doesn't mean there are zero rules. Rent increases cannot be retaliatory. Texas has a specific anti-retaliation statute under Property Code Section 92.331 that prohibits landlords from raising rent as retaliation for a tenant exercising certain legal rights. Protected activities under the Texas statute include filing a good faith complaint about a condition that materially affects the health or safety of an ordinary tenant to a government entity, filing a complaint with a government entity about a building or housing code violation, and participating in a tenants organization. Texas's anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 6 months of the tenant's protected activity. This means that if a tenant files a health department complaint in January and the landlord announces a significant rent increase in March, the increase is presumed to be retaliatory. The landlord must then prove that the increase was motivated by legitimate business reasons, not by the tenant's complaint. If a court finds that a rent increase was retaliatory, the tenant can recover actual damages, 1 month's rent plus $500, reasonable attorney's fees, and court costs. These penalties make retaliatory rent increases a costly mistake in Texas. However, there's an important limitation. The anti-retaliation protection applies specifically to complaints about health and safety conditions and code violations. It does not broadly cover every possible tenant activity. A tenant who complains about cosmetic issues or personal preferences, as opposed to genuine health and safety concerns, may not be protected under the retaliation statute. But the safest practice is to avoid any appearance of retaliatory motivation when timing rent increases. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Texas Fair Housing Act, found in Texas Property Code Chapter 301, landlords cannot raise rent based on a tenant's race, color, national origin, religion, sex, familial status, or disability. The Texas Workforce Commission Civil Rights Division and the U.S. Department of Housing and Urban Development investigate fair housing complaints and can take enforcement action. A discriminatory rent increase doesn't require proof of overt intent. It can be established through a pattern of conduct showing that tenants in a protected category were treated differently. Raising rent for families with children, but not for single adults in comparable units. Increasing rent for tenants of a particular ethnic background. Imposing larger increases on tenants with disabilities. Any of these patterns could support a discrimination claim. The best defense is consistency and documentation. Apply the same criteria for rent increases across all comparable units. Document the market data, operating cost changes, and property improvements that support your pricing decisions. And keep records showing that increases were applied uniformly without regard to any protected characteristic. From a practical standpoint, Texas has one of the largest and most dynamic rental markets in the country. The state's major metropolitan areas each have distinct market dynamics that affect how landlords approach rent increases. The Dallas-Fort Worth Metroplex is one of the fastest-growing markets in the nation, with population growth fueled by corporate relocations, job creation, and relative affordability compared to coastal markets. Rents in DFW have increased substantially over the past several years, and landlords have had significant pricing power due to strong demand. Houston, the state's largest city, has a more cyclical market influenced by the energy industry. During oil price booms, Houston's rental market tightens and rents rise. During downturns, the market softens, and landlords may need to moderate increases or offer concessions to maintain occupancy. Houston's lack of zoning also creates a unique supply dynamic. New construction can come online relatively quickly compared to more regulated markets, which helps moderate extreme rent spikes over time. Austin has experienced explosive growth driven by the technology sector, and rents in the Austin area increased dramatically during the most recent boom period. However, Austin also had a significant wave of new apartment construction that has brought some relief to the market. Landlords in Austin need to monitor supply and demand carefully, as the balance between new construction and absorption directly affects pricing power. San Antonio offers a more affordable rental market with steady growth. The military presence, Joint Base San Antonio, includes multiple installations, provides a stable base of rental demand. Rent increases in San Antonio tend to be more moderate than in Dallas or Austin, reflecting the market's overall affordability. El Paso, The Rio Grande Valley and West Texas communities each have their own dynamics influenced by border economics, military installations, and energy production. Understanding the local market is essential for setting appropriate rent levels and timing increases effectively. One best practice for Texas landlords: even though the state has minimal regulatory requirements for rent increases, treat every increase as a business decision that should be supported by data. Research comparable rents in your area using listing sites, property management reports, and local market data. Track your operating costs, property taxes, insurance, maintenance, and capital expenditures so you can quantify the factors driving your pricing decisions. This data not only protects you legally, but also helps you make better business decisions about pricing. Another best practice: communicate rent increases professionally and with reasonable advance notice. While Texas law may only require notice before the next rental period, providing 30 to 60 days notice for significant increases gives tenants time to adjust. Professional communication reduces tenant turnover and maintains positive relationships. A brief explanation of why the rent is increasing: market conditions, property tax increases, improvements to the property, helps the tenant understand the change and makes them less likely to leave. Texas landlords who participate in the Housing Choice Voucher Program must coordinate rent increases with the local housing authority. The housing authority must approve the new rent, and the proposed amount must be within the fair market rent for the area. Submit increase requests well in advance of the desired effective date. For the complete guide to Texas rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.